to another edition of Dad's Divorce Live. I'm Matt Allen, editor of DadsDivorce.com. October is Domestic Violence Awareness Month, and while most of the attention will be paid to abused women, our viewers know all too well how prevalent domestic violence against men is. Our viewers also know about false allegations of abuse being used against them. So joining me today to discuss the perspective of domestic violence against men in divorce and custody cases is Cordell Cordell attorney Heather Biagi. So Heather, thanks for joining me.
I'm glad to be here. Thank you.
Now, when a man is alleging his wife is abusing him, I assume he probably has to overcome a larger burden of proof than if a woman was the one accusing her husband of hitting her. So what is the right methodology or the right way a man should go about making his case for domestic violence?
Certainly with domestic violence, and I believe this to be the case with women or with men, but certainly with men, it's documentation, documentation, documentation. Okay? If they have experienced domestic abuse or domestic assault, certainly photographs of the injuries, certainly collateral witnesses if you happen to have those. Now, that's not always the case. Obviously, some things happen late at night or when others aren't around. Calling the police on your spouse. Again, documentation, having those third-party witnesses to back up what happened and to certainly corroborate what you're saying, because again, it's with an order of protection. If that's the main goal of one of the parties to get, it certainly all is about he said, she said.
Right.
And the more concrete evidence that a judge has, the better off that a judge is going to be able to make the correct decision. I know there's a lot of men that are apprehensive about calling the police if something happens. There's, potentially the stigma of, oh my gosh, have I actually been assaulted or abused?
Right.
Again, with the stereotypical men versus women type
Right.
of thing. But again, documentation is key in this situation.
Now, I know a lot of guys on our divorce forum on Dad's Divorce, they talk about always having a tape recorder or a video camera running, in instances where you think it might become violent. Is that a good idea? Is that type of evidence admissible?
It depends on the state that you're in, and it also depends, quite frankly, on the judge, okay? So what I would say is, I sometimes advise my client that the more information you have, the better off you are. And the more proof you have, the better off you are. But you have to be careful with, you certainly need to look up your state's laws with regard to videotaping and actually taping conversations between people, because that can get you into a separate and apart criminal world that we wouldn't want our clients to have a pitfall and fall into. Right. When they're trying to, again, it's going to be the way of the evidence. If you say, listen, it wasn't like I was tapping her phone calls, or right. I didn't tape a tape recorder under her bed to find out different information. This is actually an altercation between the two of us, and I needed to, save it for prosperity purposes. I mean, certainly that is one thing that, again, it's going to be looked at a little differently. It's not as malicious as, again, hiding a tape recorder so you can catch your wife doing something. But certainly, again, just be careful, because I would hate to give somebody some advice and their state have a law that strictly prohibits that and then have to deal with those consequences. Because certainly what you don't want is, if you have a order of protection that you've gained, then for her to come back and have a criminal case against you in
right.
in a separate realm. And obviously I'm not an expert on these types of things, but to have that case against you, they can somewhat negate one another, and certainly, again, it will have some ramifications in your divorce proceeding.
And you mentioned orders of protection. We've talked a lot about sort of how easy they are to get against a party, because it's sort of a he said, she said case. Now, claims of domestic violence are increasingly common in divorce and child custody cases because of the strategic gain to the accuser that often comes from these orders of protection. So will you talk about that and enlighten us to what are these advantages of simply accusing your husband of abuse?
I can speak from the point of view of Missouri. Certainly in Missouri, but I think that this is kind of common sense and goes for all the states, quite frankly. It's not so much that the allegation of abuse, it certainly starts the case off with some kind of taint, okay? And whether it's founded or unfounded, then the party who's accused of having some kind of abuse has to kind of overcome a hurdle that wasn't there to begin with. But more the strategic advantage for an order of protection or for some kind of domestic assault. I tell my clients when they believe a divorce is coming, to be careful about what someone might do to try to provoke them.
Yeah.
And that doesn't mean that they're violent people or that they would ever do anything like this. It's simply because the other party is setting them up to to start this altercation or whatnot, so that they do have, number one, they can say, oh, well, he's an abuser.
Right.
But more importantly, and again, at least in the state of Missouri, to gain access of the marital home. Because in the past in Missouri, judges, you could file temporary motions asking that one party be removed from the house. And back before the economy went bad, some judges would consider making a decision, do I throw husband out of the house or do I throw wife out of the house?
Right.
Since the economy, at least in Missouri, what I have found and in the jurisdictions I found, they are actually less likely to do that, because in most divorces, most people can't maintain two households,
right.
even if it's an apartment and
Yeah.
a house or two apartments. So they're less likely to throw a party out of the house as they were before. So now the only advantage, or the only way that a party can accomplish this unilaterally, is to go for this order of protection. So again, I pose to my clients when I meet with them, okay, let me play devil's advocate for a minute, and let me tell you what your wife's attorney has told her. Your wife's attorney has told her, start an argument with him,
Right.
okay? You want to start an argument with him. Hopefully it won't get physical, but even the argument, if he gets heated enough, it may be enough for you to run and get an order of protection, okay? If you're telling me you want him out of the house, the only way I can get him out of the house is to actually get that order of protection. So that's the more strategic advantage. It deals more with the house. Now, likewise, with child custody.
Yeah.
Even if an order of protection is unfounded or the allegations are something, certainly with child custody, again, there's that taint that wasn't there. And even if it's unfounded, you're going to have people like guardian ad litems or GALs or counselors or something that are going to be dealing with a problem, or even if the idea gets put in the judge's head, because in most jurisdictions, you can consolidate either the order of protection into the dissolution case, or it's heard in front of the same judge since they have background,
Yeah.
and you don't want that taint to your case.
Right. Well, thank you, Heather, again for
All right.
joining me. Appreciate it.
Very good, thank you.
That was Cordell and Cordell attorney Heather Biagi, and I'm Matt Allen, editor of DadsDivorce.com, and that'll do it for this edition of Dad's Divorce Live.